Hey, Tyler, thanks for having me. We have an exciting topic here to talk about here for the next hour, and we're looking forward to getting started. You know, the world is just changing so quickly, and it's amazing to see what has happened in the United States and around the world in the last 18 to 20 months. And it's amazing to see quotes like this that have appeared in magazines and industry publications really all over the world. I think they're headlines and quotes that I could tell you, Tyler, would have never expected to read. Referring to the United States as a U.S. tax or privacy haven, or referring to the United States as the new Switzerland. And the idea that somehow the United States is now the place to be for international families is, again, I think, a reality that none of us expected. I think it's a reality that none of us are, in many respects, were prepared for 18 or 20 months ago. And it's something that we did not create. I think the reality is these observations that have been made by experts around the world is a result of a confluence of several different factors. And there are factors, again, that we didn't create, certainly the United States didn't create, certainly Bridgeford didn't create, but there are factors that we need to be aware of nonetheless. And I think that as this world changes so quickly, we collectively need to be leaders and anticipate what's happening in the world, what has happened in the world, and how to best position the United States trust industry and really the financial services industry to best serve these families in a way that protects the integrity of the international or the domestic trust system. I think that we have lots of things we want to talk about today, but the theme is in big picture sort of format. And we need to understand what's driving all of this activity into the United States, and it's fascinating. I think we have to have the courage to acknowledge the fact that there are certain things happening around the world that is making this happen. I think we need to talk about then what happens when these people come to the United States, these international families, and how best to address the needs that they have, because they do have some very real needs and very legitimate reasons for being here. And then we need to talk about how to best support the system. In other words, how do we weed out bad actors? How do we make sure the integrity of the entire system is maintained, and that we're protecting, again, the integrity of what we can offer here in the United States? It's an important question, and I think as we get to the end of the presentation, we're going to focus on things like the importance of really very detailed Know Your Customer, otherwise known as KYC. We're going to talk about what South Dakota is doing in terms of making sure that that state is prepared to not only be able to service these families, but make sure that we're not aiding and abetting illegal activity or otherwise presenting the United States as some sort of a tax evasion haven or secrecy haven, because that's not what we're talking about today. That is not what we're certainly selling here in the United States. It's certainly not what Bridgeford is selling. But what we are doing today and what Bridgeford is doing in South Dakota and other progressive trust jurisdictions is being responsible and being the leaders that we are by acknowledging that this is happening and acknowledging that we need to be prepared for it and we have to have the right regulations in place. So with that, we will get started. Coming to America, you know, there's a myriad of reasons why the United States has become such a target for international families. Education purposes, people come to the United States for education. They get married, and they stay. They start businesses. And, you know, the most important aspect here, I think, initially is to people coming to the United States is there seems to be a presumption we want to avoid, Tyler, and that just because somebody wants to come to the United States doesn't, by definition, make them nefarious. I think that's there are great reasons to want to come to the United States, and I think that what we want to avoid is sort of that prejudice that when you look out into the world, because somebody may want to be part of the U.S. trust system doesn't necessarily make them bad by definition. But that's where the devil is in the details, and we're going to talk about that towards the end of the webinar, because it's our responsibility to make sure we're not dealing with nefarious or bad actors. But again, in the context of not presuming they are just by virtue of wanting to be in the United States. You know, tax and privacy issues. You know, as you see from those quotes, as experts have acknowledged for the last 18 to 30 months, there are things that have happened in the world that we collectively didn't anticipate, that has made the United States an interesting destination for tax planning, not tax evasion. very important point and a very important theme that we're going to focus on throughout the whole 50 minutes together. There are privacy laws in the United States, particularly South Dakota, that have been on the books for a long time, and that's not secrecy. So that's very important to draw those distinctions as well. Privacy and secrecy are very different, just like tax planning and tax evasion are very different. And, the idea of the Panama Papers, I think I can remember when the Panama Papers happened. And the reason why I mention it, because it's one of those myriad of factors that have sort of shaken the international community and have made the United States more of a destination. The Panama Papers involved, as we all remember, a leak of information from a law firm in Panama. And it exposed the existence of lots of different structures from lots of different people from around the world. And that shook up the world to the extent that it raised the question of the security of how information is held. And then it led to different questions about the propriety of the structures that were in place and whether these very famous people or very wealthy people were really doing anything wrong. And it gets sort of to the point, as I made earlier, by definition, people who are in Panama weren't bad actors. Or by definition, people who want to come to the United States aren't bad actors. And in fact, most of the people that were involved in the Panama Papers weren't doing anything illegal at all. And in fact, I think a statistic I saw was something in the low 90% of the people's names who appeared on that list didn't do anything wrong. Maybe they were embarrassed by the fact that their information was revealed, or maybe they had real reasons for their information not to be revealed, but they weren't bad actors. But that really was a proverbial bomb that went off in the international community that really created this question as to where information should be held and how it is held. And then domestic asset protection versus offshore asset protection. We all remember how this concept of asset protection became pretty red hot 20 or some years ago or longer. People went offshore for that, which was legal. People created structures that were perfectly legal. And now, in light of the Panama Papers, in light of the confluence of events that we've mentioned so far, and we'll get into in more detail, the United States has been looked at now as an asset protection destination for folks. And South Dakota has become has a specific set of laws in place that make that an interesting conversation. We can't talk about the international community, and we can't talk about international planning without acknowledging the existence of the Common Reporting Standard, otherwise known as CRS. And so when you look at all of these factors as to what's driving activity into the United States, and you consider them sort of one at a time, we come to the conclusion, again, there are lots of reasons why people want to be here, and it isn't any one particular reason. And in fact, if it is one particular reason, particularly the CRS avoidance, then that's something we have to be careful with and guard against. And we'll talk about that more specifically.
Dave, I know before today's webinar, we had talked a little bit, and you were telling me a lot about privacy versus secrecy, and you have it there, privacy laws, not secrecy laws. Can you talk a little bit more about that, just to give some of our viewers a better foundation of what you mean by that, and also kind of which side of the spectrum you're on and what you're advocating for?
Absolutely. I think secrecy and privacy are extremely distinguishable. I think when we talk about the regimes that had existed in Switzerland for many years, there were people going there for specific reporting reasons, which is to say they wanted to hide money. They wanted to hide activity. And Switzerland and other organizations or other countries created laws that sort of made that easier to happen. Whereas privacy is separate. And what we do in the United States, particularly South Dakota, is we talk about privacy in the context of keeping information out of the public domain, not hiding information from appropriate authorities, which would be the tax authorities or the governmental entities that are looking out for terrorism. Those are two very, very different aspects of a same general concept. But here in the United States, particularly South Dakota, and absolutely at Bridgeford, we're not selling secrecy. And I think it's important to make that point. And I think in the context of that entire conversation, before we move on, whether we like it or not, Tyler, whether Bridgeford likes it, whether South Dakota likes it, or whether the United States likes it, there are a set of circumstances right now that exist in the international community that are driving activity and driving very wealthy international families into the United States. So again, whether we like the fact that the United States is called a tax haven or privacy haven, and that big publications around the world have consistently said that for the last 2 years, doesn't matter if we like it or not. As leaders and as professionals, as well-trained individuals, we have to prepare for that reality, make sure we're doing this right, and make sure we're doing the type of research and due diligence on folks coming to the United States so we don't create an environment where we are a haven for secrecy or we are a haven for tax evasion. Because, again, I make that point. That is not what we're talking about today, and that is not what we're doing here in the United States.
Yeah, and I think that's why we're really excited to hear you dig into some of this more. Obviously, these are factors and issues that we can't ignore. You know, we have to be aware of them so that we can provide the best services that we can to our clients. So why don't you dig into Common Reporting Standard a little bit more for us?
Absolutely. I mean, the idea of Common Reporting Standard really isn't that complicated. It's very similar to FATCA. I am sure most of our folks on the line are familiar with FATCA. We have people, I should have said earlier, from all over the world that are a part of this webinar today. So a lot of these concepts are not new to them. But what makes the Common Reporting Standard so salacious, Tyler, for lack of a better word, is that it imposes a global cooperation and sharing of financial information between and among participating jurisdictions, with the goal of enhancing transparency with regard to multinational activities and business and reporting. So that simple definition is a good thing, Tyler. We want this. This is in the age of terrorism. This is in the age of tracking money. This is in the age of trying to get people to pay taxes when they're supposed to. So in and of itself, this is a very good concept and something that I think we should embrace really around the world. It's similar to FATCA, and we're going to do a little bit of a comparison. But FATCA grew out of the same set of concerns, but it was specific to the United States and United States citizens, which is to say, the United States years ago recognized the same concern and wanted to be sure that United States citizens weren't going around the world to places like Switzerland or the Cook Islands to evade taxes or seeking secrecy, which is differentiated from privacy, as we said before. So FATCA was born out of that paradigm, and then CRS was born out of the same paradigm, but more in a global stage. You know, as of August 2017, the most recent number I saw was that there's 102 jurisdictions that have committed and implemented, or are going to implement over the next 2 years, CRS. And that includes some pretty big countries and locations like the Cook Islands, BVI, Switzerland, New Zealand, and Nevis. And I put these as an example because these jurisdictions have traditionally been the most sought-after jurisdictions over the years for asset protection, for effective tax planning. In some cases, I'm sure they were used in a nefarious way, but by and large, they were legal activity. That was legal activity that was happening with people who did not necessarily have a nefarious approach to what they were trying to do. Why that is fascinating and why this is having a big impact in terms of the debate around the world right now is the United States has chosen up until this point not to participate in CRS. So the question might be, well, what does that mean and why does it matter? It means that the United States is not, again, participating, but more particularly, the United States is not sharing information with the global community that it gathers through FATCA. And so we can debate whether that's a good thing or not, and we can get into the realities of what that means for the global world economy and how that impacts the movement of money. But it doesn't matter. At this point, the United States is not participating. Some say they're going to at some point. Some say they're going to have to. But this is what I mentioned earlier. These are a set of facts and circumstances that we didn't create, that we have to deal with, and we have to figure out how to handle.
Yeah, and as you mentioned, I mean, CRS is extremely similar to FATCA, but there are some key differences. So why don't you jump into those differences and how CRS is different from FATCA?
Certainly. As I said, they're similar in many ways. I think the most important distinction is that FATCA was designed, as I indicated, to deal with U.S. citizens and to protect against U.S. citizens going into foreign jurisdictions to evade taxation and to seek privacy where not appropriate. There's about 100 countries that have signed up to FATCA, which means they honor the disclosure of information with respect to United States citizens. And again, the aim there, or the objective, was to reduce tax evasion by U.S. citizens and U.S. residents, tax residents around the world. So again, going to Switzerland, going to the Cook Islands, just to avoid paying taxes. which was a big deal, especially back in the 80s and 70s, and in fact all the way back to World War II. CRS, in theory, is similar, but it's a global initiative, and its aim is to reduce or address the exact same type of concern that FATCA does, but it involves the international community. It involves, and when the countries are signed up, for lack of a better way of saying it, for CRS, that means they've agreed to gather this information and share it among the countries that are participating, whereas the United States gathers this information through FATCA but does not share it with any other community or other country. So really the key differences are, as we pointed out, FATCA focuses on U.S. persons and trying to stop the use of going to their offshore jurisdiction for nefarious purposes. And it only involves U.S. account holders. And again, the CRS is a global reach, and the information really has to do with all account holders. Before we move on, the controversy around CRS and the conversations and the comments that I've heard as I've traveled around the world, Bridgeford does more and more international work, is that CRS has created this, and I put in quotation marks, tremendous opportunity for the United States to capture all this business. And I think that's an unfortunate way of looking at it. And I don't know what the motivation is for the United States not signing off on it. And I'm not even going to get into that conversation today. But the reality is, are people coming to the United States because they would want to avoid CRS? Probably. If that's the only reason why they're coming to the United States, then we need to understand the bigger conversations. If they're coming here to avoid tax reporting because they're tax evaders, we don't want them. If they're coming here because they have specific reasons for secrecy, like because they're on the run from law enforcement, we don't want them. But the reality is, as I've said several times, is we didn't create this dynamic that's going in the world. And the devil is in the details. And I've said it before, and we'll say it again at the end. The devil is in the details, and the responsibility falls on leaders like us to make sure we're not dealing with these bad actors. So there's a way to have this conversation, be a world leader, but make sure we're protecting us at the same time.
So you're saying that not everyone who wants to come to the U.S. for a myriad of reasons, for some of the benefits of citing a trust within a U.S. trust jurisdiction, they're not all nefarious. They're not all bad actors.
No, and there's a sad reality, Tyler, that a lot of people don't, it's becoming more and more real, but there's a sad reality. It's a fact that in Mexico, if a wealthy family is revealed to have the kind of wealth that is big wealth, that information can and has very often led to kidnapping of children. Violence has been documented as a result of some of this information being put out into the community. So there's the distinction again. There's privacy, which I think we'd all agree. We all have the right to privacy. You wouldn't want any information about your finances being out into the public. And then we have the same conversation in the international world. So there are actually real reasons why people would want to have a modicum of privacy relative to their net worth. We are lucky in the United States. We pay lip service. We're so lucky. We're one of the world powers, and we don't have any of these issues. We don't have to worry about these issues in terms of my son being kidnapped at college, because if somebody were to find out that I was worth $1 billion. And so to diminish the world community's concern on that issue is unfortunate, and I think something that we can't take lightly.
Yeah, I appreciate you taking the time to talk about this and the key factors of CRS versus FATCA. We did have a question come in that I feel like would be a good time to talk about it, and I know you didn't want to jump into it too much, so just very briefly, can you answer, do you envision the U.S. ever signing up for CRS?
Well, that's a hot topic. I'd be interested. I think you can get 10 people in the room, and 10 people would have different answers. I do believe eventually the United States will have to become a part of it. I think that there are myriad of political forces and reality. Practical reasons why the United States would have to become a part of it. I think there was some talk when President Trump became the president that there was no way we were going to sign it, given his approach to governing. I think it's a fascinating question to watch very, very carefully, and it has an impact. That whether or not the United States signs on that is going to have an impact on this conversation.
Yeah, and we're going to transition now a little bit to the best, what are the best trust jurisdictions, and maybe for some of these international families who might be looking to come to the U.S. for trust situs. So we're going to jump into that, and I know this is a quote that Bridgeford uses a lot about wherever you establish a trust is such a key and critical component of the whole trust administration process. So, Dave, why don't you just jump into some of the benefits of U.S. trust situs, and more specifically, some of the benefits of South Dakota?
Absolutely. Once we kind of come to the conclusion that, not everybody coming to the United States is nefarious, and B, there are some really good reasons why coming to the United States makes a lot of sense, then we have to get more specific. And this is where Bridgeford is particularly passionate about. We look at these issues very carefully. And as you know, Tyler, there's no such thing as a United States trust law. It varies from state to state. And that's why this quote resonates so much with us and our clients and our advisors, is that now if we go through the steps and an international family wants to be United States for the right reasons, and we do our due diligence and we decide, yes, this is somebody that is not going to be anybody we need to be worried about, then the question is, well, where should they go? And this is where this international conversation becomes so intriguing, because this conversation is happening in the international community. The international world is looking at the United States, realizing that there's a distinction between South Dakota, Delaware, Nevada, and Alaska. They realize that there's been a race in the United States relative to who can be the best jurisdiction. And advisors in Panama and I've spoken to directly, and London, in Italy, and all jurisdictions that we've worked with, Cayman Islands, they know that there is this proverbial race right now. And they also know that it matters in terms of which jurisdiction that you choose. And so, as we said, the top tier trust jurisdictions are considered to be South Dakota, Delaware, Nevada, and Alaska. And what we're going to do is sort of go through some of the topics as to why these jurisdictions are considered the better of all the trust jurisdictions in the United States. Make some distinctions that are very, very important. And then once we get through why that matters and how we determine which state to be in, then we're going to transition into some really important issues, like how do we do appropriate KYC, know your customer, and how do we understand that we're not dealing with a nefarious actor who wants to come and take advantage of all the advantages that we're going to talk about. And then we're going to look again at what South Dakota is doing to make sure that we're protecting ourselves from the bad actors. So we all are familiar with asset protection, the idea of dynasty trust or the rule against perpetuity taxation, privacy rules, modern trust laws. These are the factors that are driving activity not only now in the United States but around the world. Families and advisors around the world are looking at the states, and they're evaluating which state has the best asset protection statute and which is considered the best dynasty trust. So what I thought we would do is go through each of these factors, because these are the factors that the experts in the United States look at and compare to sort of come to some not so much conclusion, but understanding just how important this jurisdiction selection is. So again, just choosing the United States is only half the conversation for these international families. Now it's, which state should I be in? And so asset protection has been around now for a long time in the United States. It's different in the United States for a lot of the people on the webinar. I'm sure you know it. What makes it sort of unique is that it's a self-settled trust, which gives settlers a lot of ability to access income. It's been held to it's designed to shield from third-party liability, and it's been on the books in the United States for at least 20 years. And there's a debate as to whether or not domestic asset protection will actually work. As we sit here today, there is no single case in the United States that has overturned a domestic asset protection trust, regardless of the hyperbole that you may read in newspapers or in different advisors. Where they've been challenged is by virtue of the fraudulent conveyance aspect of it, which is to say they were bad facts. Somebody knowingly put assets into a trust that they shouldn't have. Most states do not have an asset protection statute. So again, this conversation is so important for an international family who's leaving the Cook's Island because they're there for asset protection purposes or NEVIS, coming to the United States. They need to understand which state matters, or rather which states are considered the best. These 4 states have been considered the best for years, and that's people like Trust in Estates magazine and law review articles and professors have looked at that. and they have been consistently considered to have the most robust asset protection statutes. What's important for the international community to understand is, although those 4 states are considered the top tier jurisdictions for this purpose, there's some important nuances, and as they say, that the devil's sort of in the details. And in the fraudulent conveyance statute's the big one. South Dakota, it's 2 years. Delaware, it's 4 years, which means that asset protection doesn't really attach until after the passage of 2 years. That's an important distinction. But probably what's most interesting right now is this little-known ability in South Dakota to actually have the best of both worlds. Because of the Panama Papers, because of some reporting requirements that didn't exist 2 or 3 years ago, because of the fact the United States is just considered to be a more stable financial environment, there's been this debate about, well, should you go offshore, should you go onshore? And now under South Dakota law, there's an ability to do both, which essentially, and I won't go into the details here, talks about the ability to have a domestic asset protection trust, but have, upon a triggering event, that trust become an offshore trust. And that's something that is somewhat unique to South Dakota and has been extremely interesting to international families from around the world as they realize that South Dakota has that capability.
Great, thanks, David. Now we're going to transition into dynasty trusts and really the advantages that dynasty trusts have for wealthy families to extend their wealth over generations. So can you just dive into dynasty trusts?
Absolutely. And this is another extremely interesting topic for the international community because we are, we being the United States, was one of the first to take a look collectively at the rule against perpetuities and create this environment to have a trust live forever. So now, because of how long ago South Dakota was the first to abolish it, we've sort of become accustomed to the fact that we can have trusts live forever, which means that they're never going to be subjected to, the assets are never going to be forced into being taxed by the federal government. So again, that's a planning tool that most of us have become familiar with, but when you talk about that in the international community, that gets a lot of people's attention. They didn't realize that was an option, and I can tell you how many conversations I've had in the last 6 months with advisors from around the world who didn't realize we can do that in the United States. So, it protects family wealth over generations. And not all states are created equally in this respect, and there's some things to consider. And this is where, again, the nuances matter, and I've said several times, and again, the devil's in the details. So when we look at the comparison of these dynasty trust states, it's important. The chart that you're looking at is a chart that was created by Steve Oceans, who's a very prolific and well-respected attorney based out of Nevada. And as you can see from the chart, he does a really nice objective job of comparing various aspects of what you can do in these dynasty trust states. For example, they look at the domestic asset protection statute, and they look at the aspects of the rule against perpetuities and whether or not it was actually abolished or modified. And that's an important point, Tyler. That's what draws distinctions. Whether it was abolished or modified makes a big difference. So, for example, the United States, in South Dakota, it's been completely abolished, which means that it will never ever be a factor. In states like Nevada, it hasn't been completely abolished. In fact, 365 years is when actually a trust can end. And that's great on its face, but some folks look at that comparison and think, well, why shouldn't I just go to the state where it's completely abolished? But what I love about the chart is that it's objective. It's not something that Bridgeford put together. It's something that an attorney, again, who looks at these issues have looked at. And it's not subjective. And it says that South Dakota is the number one trust jurisdiction. It has been the number one dynasty trust jurisdiction for the past at least 5 years. And that's an interesting commentary. And Steve Oceans produces all kinds of charts like this. And we'll look at another one later.
Great. Well, before we move on to the next topic, Dave, there was a question that came in about dynasty trust related to CRS. So the question is, if the U.S. signs off on CRS, will the assets in these dynasty trusts still be held in absolute privacy?
Well, under the laws of South Dakota, the answer would be yes, and we will thank you for that question. And we'll talk about the laws of South Dakota with respect to privacy. The privacy laws of South Dakota have no connection to CRS. CRS and the privacy laws passed by an individual state are wholly unconnected. So the shorter answer is yes. If the United States signs off on CRS, Privacy laws would still apply in South Dakota, but to be clear, and we'll talk about, they're not laws designed to keep nefarious activity secret. They're designed to keep personal information out of the public domain, but that's an excellent point.
All right, and with that, we're going to transition into trust taxation, and especially with South Dakota, all the advantages and the significant tax savings opportunities that South Dakota has to offer. So jump into trust taxation, Dave.
Absolutely. There are a handful of states that do not have an income tax at all. And so there's sort of a simple way of avoiding a tax, which actually, when you look at, you think, boy, it doesn't really make a lot of sense that it would even be in place at all. But there's a tax that most states have imposed on resident trusts. And the idea of a resident trust is a trust that's situs and where trust administration is in a jurisdiction other than where the settlor, beneficiary, or co-trustee resides. So let's just use Pennsylvania as an example. Tyler, your family sets up a trust. You set up a trust in Delaware or South Dakota or Nevada or any other of these trust jurisdictions that do not have an income tax. And for years, undistributed income has been taxed at the state level in each of these jurisdictions. So, for example, Pennsylvania would tax undistributed income at the trust level at a little over 3%. New Jersey, I think it's closer to 6%, over 6%. North Carolina is even higher than that. But there's a trend in the case law, which is to say that it's unconstitutional for a state like South Dakota or New Jersey or North Carolina, which is that those are states that actually have case law right on point, that talk about the fact that it's unconstitutional for a state to tax an entity that's not even under its jurisdiction. So that's where sort of the planning opportunity exists. These are the three cases that I had mentioned, and essentially what they're saying is all of them say the same thing. It's a violation of the Commerce Clause of the United States Constitution and due process for a state to tax a resident trust properly situs and administered in another state. Now, there's an important nuance, and that this only applies to liquid assets. Sourced income in the state is still going to be taxed at the state level. Now, again, this is a simple planning nuance, but when you combine this with the Dynasty Trust, we're looking at a situation that trust jurisdiction really matters, and it really matters for the international family now as they're looking at these nuances. So again, we have this compelling planning opportunity to look at it through the Dynasty Trust and understanding state taxation in a way that really does make a difference. And I argue that this is one of the most measurable ways of looking at the importance of trust jurisdiction. We can put a number on now what it would cost if somebody put this trust or a trust in a jurisdiction that has an income tax. And so I think just understanding these differences makes a huge difference for families around the world now. A very exciting development, and this is something that has become particularly interesting for the international families that are coming to the United States, is the idea of a South Dakota Community Property Spousal Trust. And this is a very simple concept that before South Dakota passed its statute only existed in Tennessee and Alaska. And South Dakota's has been acknowledged as being sort of the strongest at this point. And what it does is it takes what has been traditionally in community property states, a 50% step-up in basis. It brings it up to 100% step-up in basis at the death of the first spouse. So where this is particularly interesting or compelling from a tax planning perspective is where a husband and wife hold a lot of joint property, and they have the ability now to create this community property trust, and at the death of the first of them, avoid all of the taxation, the capital gains taxation rather, at the state level. This has been looked at by various PLRs. This has been looked at by various tax experts from around the country. We do this a lot in California. And really the message here is, and the idea of trust taxation is, by combining this planning nuance with a Dynasty Trust and understanding how we can avoid taxation at the state level relative to undistributed income, we're talking about some really powerful tax planning moves. So I purposely emphasize it's planning. What I'm not talking about, Tyler, is tax evasion. And this is the reason why people are going to jurisdictions like Delaware, South Dakota, and Nevada, and Alaska, and in some cases Wyoming. That's why they're doing it in the United States. And that's why international families are coming to the United States as well, to do good trust tax planning, not tax evasion. A very important distinction.
Yeah, it's incredible as we go through these slides to see the advantages and the significant amounts of money that families and estates can save by situsing a trust in South Dakota through, like you said, proper tax planning. But something else that South Dakota is certainly leading the charge in is privacy and their total seal. So can you talk about that more?
Right, and that gets back to the great question we had before. The South Dakota privacy provisions, again, have nothing to do with FATCA, have nothing to do with CRS. This is a matter of state law. And state law here, particularly in South Dakota, has been recognized as being the most powerful privacy provisions in the United States. Again, not to protect people doing nefarious acts, but to protect information that's private from entering the public domain. There's a quiet trust, which is the ability for a trust in South Dakota to be written in such a way that beneficiaries do not have an automatic right to receive information about the trust's existence or its size or how much they're even entitled to. So this comes into play when you have a very, very wealthy family whose son or daughter turns 21 and they're in college. Most states require mandatory disclosure of the existence of that trust, but it might surprise you that most wealthy families would prefer their children at the age of 21 in college don't know that they're the beneficiary of a $25 million trust. And so this quiet trust provision, again, is a way to control the dissemination of private information, even to beneficiaries. Somewhat controversial, and it's not a matter of law that you have to do this in South Dakota. It's just an option that people have to exercise, and we see that more and more. The other aspect of this is the court seal. This is another way private information finds its way into the public domain in the United States and really around the world, is when a trust finds its way into litigation for whatever reason, whether it's for whatever, if it's a will contest or a disgruntled beneficiary, that information goes into a court docket system, often with hyperlinks, and virtually all of the information relative to the trust can become part of the public record, which means you can find out who the settlers are, what's in the trust, who's actually managing the money, who the beneficiaries are. Well, as you can imagine, people wouldn't want that information to come in. Not because they're trying to hide anything, but because that's personal information that I think is reasonable to have an expectation to protect. South Dakota agrees and has a court seal, which means that it's automatic. So in other words, it's not discretionary. In states like Delaware, they do have a seal, which is only for 3 years, incidentally, whereas South Dakota's is forever. But really, the most interesting aspect to it is you don't have to go to court to ask permission to seal it. And that's where families from around the country and now around the world like that idea that they don't have to ask a judge for this type of privacy. And it works very well. Now, most states, it's important to note, Tyler, this information is open to the public. So I think you would agree, as I've described privacy, I think we've nicely distinguished it from secrecy. And so when we're talking about, like, that great question about, well, how does CRS impact it? I think now as we have had this conversation, I think we see very clearly they're very different concepts. CRS and FACTA are protecting against secrecy and trying to avoid getting caught doing bad things, for lack of a better way of saying it. Privacy provisions in South Dakota, that's not what they're designed to do. They're designed simply to keep public information or information from becoming public that is private that we all should probably have a right to expect.
Yeah, absolutely. And as you touched on in the beginning of the webinar, we're doing this to meet our clients' needs. We're trying to respond to the systems that are in place and to provide the best service that we can with these great privacy laws that South Dakota has to offer. So now we're going to transition into some modern trust laws. And if you've been on Bridgeford's website, if you've seen their YouTube channel, Dave, I know you've talked about a lot of these topics in detail, and we're trying to keep track of the time here and make sure we get done in time. So we're going to go through some of these pretty quick to make sure that we can get everything that we want to get covered in today's webinar in time. So first, Dave, why don't you jump into directed trust and just touch on that really fast?
Absolutely. All of those modern trust laws are so exciting because they create a level of control that never existed before. The directed trust, to me, is one of the most revolutionary aspects of this ability in the United States to exercise control. And I can tell you, is a concept that is resonating around the world right now. And in international families who want to come here, that's what they want to have, is control. And the idea of the control is simple and easy to follow by looking at this chart. Through the directed modern trust structure, we bifurcate responsibilities in a way that gives control back to the settlers of trust, to their advisors, and in many cases to the beneficiaries, to be able to control who manages the money. The traditional model, Tyler, and the model that I grew up in is if you had a trust at Bank of New York Mellon or PNC, they had to manage the money for you. And whether or not they were good isn't even the point. You had a lack of control. This structure gives that power back to the family to work with an investment manager that they want to. It splits up the functions, and it allows for really an entirely different structure of trust administration that in some ways diminishes the power of the trustee, but gives much more power back to the settlers and, as I said, families and advisors. And it's an exciting time. Where the power goes to reside with respect to the directed trust structure is in the next concept, which is the idea of a trust protector. The trust protector, or referred to as a super trustee, is another revolutionary concept that, by the way, has existed in the international community for many, many years. We just brought it recently here to the United States. And so where the directed trust sort of diminishes the power of the trustee, rightfully so, I believe, it concentrates a little bit more power into the idea of this trust protector, which has unbelievable power relative to the selection of a trustee, jurisdiction considerations, distribution considerations, selection of asset managers. And we love this concept because it creates so much more flexibility into the overall trust planning and trust administrative function. And it gives, again, power back to the family and their advisors in a way that just creates so much more flexibility and has changed, in our mind, the face of the trust community. The key about the trust protector, though, that creates some consternation is that it's actually considered a fiduciary under South Dakota law. So South Dakota and most law, I mean, each state that has a trust protector, it usually is elevated to the position of fiduciary. So a lot of you on the webinar may say, why does that matter? Because often people, settlers of trust and their families, want individuals to serve in the context of a trust protector who can't do so because their regulatory body won't let them, like investment managers, the lawyers in some cases, accountants. So South Dakota was the first state in the nation to develop something called a family advisor, which has many of the same powers of a trust protector, but is not a fiduciary role. This is, again, another really revolutionary aspect what is happening in the trust space. And I've said many times, this is what makes the trust world so dynamic and exciting to me. Having come out of law school, I say all the time, I didn't like trust in the States. I thought it was boring. I thought it was very stodgy. Now we have these concepts like the directed trust and trust protector and the ability to create so much more control for settlers and their families that it's a whole new world now. And it's exciting and it's dynamic. And the family advisor is another example of that. And it's exciting that South Dakota was able to create that. And why they did it is they wanted to create a position that had some power, not as much as a trust protector, to remove and appoint a trustee, make other important decisions, but not be a fiduciary. That's the key. This position is not a fiduciary, which means that there's less likelihood that this person may be sued. They're held to a different standard. So that satisfies the problem that we have seen where a family wants a particular individual to do this, but they don't want to do it because they're worried about liability, or they don't want to do it because FINRA tells them they're not allowed to do it. And so this is, I think, a brilliant move. I can tell you it has been many reasons why South Dakota has been selected over other jurisdictions in the last 6 months for Bridgeford as we have this conversation. So decanting, this is to me one of the final and most exciting aspects, somewhat controversial, but something that has become really interesting to the international community, which is the ability to decant a trust just like you would a bottle of wine into a new trust with different and presumably more desirable and flexible provisions. So what we have here in decanting is the ability to essentially breathe new life into an old trust that may not be performing the way it was supposed to when it was drafted 100 years ago. There's an ability to change jurisdiction to a jurisdiction that's more progressive. There's an ability to make some very important changes into the trust document without necessarily, you don't necessarily need to go to court to make this happen. And it's become one of the most powerful planning tools for professionals, not only again again, in the United States, but internationally, because we have these trusts that, tell us sometimes they just don't work the way they're supposed to anymore. Or maybe somebody wants asset protection, but the trust is in Pennsylvania and there is no domestic asset protection there. Or they would like to have more privacy, and so they find the jurisdiction that has more privacy. So here's a list of when to use decanting. We see it most prevalently in the idea of changing situs to a more progressive trust jurisdiction. We see it also in the idea of when I say breathing new life, we can take these trusts and make them directed trusts, which again gives much more power back to the beneficiaries, the ability to add trust protectors. So these modern trust laws get me pretty excited because, again, it's changed the entire dynamic of the trust industry and has allowed us collectively as professionals to be responsive to the needs of folks that need trusts.
And Dave, before you jump into talking about which states have decanting statutes, we did have a question that came in about the trust protector relating to decanting. So the question is, so the trust protector has the right to instruct on decanting or to initiate maybe the transfer to a more progressive trust situs?
Absolutely. In fact, we like that model. So the trust protector would have the ability to direct Bridgeford to do a decant. So without getting too much into the details, the idea is that when there's a decant of a trust into a new trust, that's at the initiation usually of the trustee, which is to say would be Bridgeford, or at the direction of a trust protector that tells us to do that. So the short answer is yes, and that's a great way to do it. We like it. We'd rather be directed in that capacity. That makes things much smoother, and it makes sure that we're honoring the wishes and concerns of the family. So they're not all created equally, just like we don't have, just like the Dynasty trust states aren't created the same, and we all have, and they have different nuances that are important to establish when you're looking at that. And again, you have somebody like Steve Oceans who's taken the time to do a great comparison of the decanting states, puts together again another objective chart, and for the fourth year in a row, he finds South Dakota's to be the most flexible and really the best decanting statute in the country. So why does that matter? We've been talking earlier about the nuances and the devils in details. It matters if decanting is something that's really important to you. And if a family needs the most flexibility from a decanting perspective, they need to find a jurisdiction that is going to give them the most flexibility. If a family is concerned about privacy, they need to understand which jurisdiction is considered to have the best privacy provisions. And again, this isn't a situation anymore that's specific to families in the United States. People outside the country know these jurisdictions are the jurisdictions to be in. So charts like this are fantastic because they're objective. Again, they're not the opinion of Bridgeford or me or you, Tyler. They're the opinion of people, and particularly Steve Oceans, who follows this very carefully. And I appreciate his work on these.
All right, we're going to jump here into a chart that was actually created by Bridgeford Trust Company. And, so we talk about Dynasty Trust, domestic asset protection, directed trust, the trust protector, all these factors. And again, Bridgeford is obviously a huge believer in South Dakota, their progressive nature and leading this industry. And so, Dave, can you just go over this chart really quick? And, we've had people on today's webinar submit questions about why we consider South Dakota better than state, X, Y, or Z. And so we compared South Dakota to 4 of the other leading trust jurisdictions. And again, we believe that South Dakota is the right way to go. So can you talk about, from your perspective, just highlight these topics and how South Dakota is leading that charge?
Certainly. Before we get into those distinctions, I think it's important to sort of pause. While it sounds self-serving because Bridgeford is a South Dakota trust company, that we think South Dakota is the leading just jurisdiction. Sure, that certainly is self-serving, and I recognize that. But the reality is, when you compare these jurisdictions objectively, there are nuances that distinguish them over each other. And I think that as a planner and as I practice law, to me, as long as you're in one of these jurisdictions, you're better off than being in a jurisdiction like a Pennsylvania or California, certainly, or New Jersey. So I want to sort of say from that perspective, when you're in a top-tier trust jurisdiction, you're doing the right thing. But that doesn't end the inquiry. And that's where Bridgeford took the time to create this, what we believe to be a very objective chart, well cited, as you see from the bottom, that in shades of gray, that's funny, they're not shades of gray, they should be a more definitive color, but the shades of gray indicate where South Dakota has been acknowledged to excel, which is, again, we've talked about the Dynasty trust space, the community property trust state capability, which most states don't have. The decanting statute is considered to be the best. I've already mentioned the trust provisions or trust privacy provisions have been universally considered to be the best. The family advisor is South Dakota is the only state that has that, and there's another particularly specific planning nuance called a special purpose entity that, again, South Dakota is the only state to have codified. So when you look at this information in the aggregate, there tends to be, in our view, in the view of advisors around the country and around the world, some compelling reasons why maybe South Dakota would be a better answer. Now, there was a question that came in as to why we haven't mentioned South Dakota as top tier, or rather Wyoming, is top tier. It's not because of our opinion. It's because usually Trust in the States magazine and others do not include them as a top tier trust jurisdiction. However, we included them on this chart. So for the purpose, per person who asked the question, take a look at the chart, and you can see some comparisons. It is a very strong jurisdiction, but in our view, it isn't quite, or at least not our view, the view of people smarter than us, that it's not quite yet considered top tier, but has some strong attributes to it.
Yeah, so again, through this chart, it's pretty understandable why South Dakota is the clear choice. But going back to CRS and kind of the international space, is there a framework, Dave, for foreign families that want to come to the U.S.?
Absolutely, and I think that this transitions back into the dynamic that's happening around the world, that whether we like it or not, whether we are prepared for it or not, families are coming to the United States, and there are particularly planning opportunities for foreign families in appropriate situations, and it's in this instance a U.S. foreign trust or grantor trust is something that is becoming particularly hot right now, because essentially if it meets or fails certain tests as outlined by the IRS, it wouldn't be subjected, the trust itself wouldn't be subjected to U.S. taxation. But however, for legal purposes, it's considered a South Dakota governed document, which means all the bells and whistles that we've been talking about apply. So they really, when I say they, international families really can get the best of both worlds. So why a foreign trust or a foreign grantor trust? And we list some of the reasons. But this is one of the planning opportunities that we've been talking about around the country. We get lots of questions about this from around the country and around the world, and it's something that has been something we're doing a lot of at Bridgeford.
Yeah, and you talked earlier about KYC, know your client or know your customer, and you're going to touch on it here in this next slide. So can you talk about this and how you best protect yourself, how you best protect Bridgeford Trust Company, and even how the industry can protect itself, from being taken advantage of or to weed out these nefarious actors so that, you're doing this for the right reasons?
Tyler, I believe this is probably the most important aspect of what we're doing here in international space. We talked about why people want to be here, why they're coming here, and the dynamic. And we talked about the distinctions of being able to provide an environment for people to be here if they want to be here, not to evade taxes or not to be seeking secrecy but privacy. But how do we find that out? The question, I've made some nice statements about and distinctions, but how do we get to that point? And this is the answer. The know your customer and the amount of due diligence here is the answer for Bridgeford. It's the answer for South Dakota. It's the answer for the entire trust in financial services to protect against the bad actors. And so a strong KYC program, which we have at Bridgeford, is designed to weed out these nefarious people. There are substantial world checks that we do and lots of other trust companies do, which means there are online services that search the whole world for bad information that could exist about a potential settler of a trust that wants to come to the United States. LexisNexis happens to be one of the best. WorldCheck is another one. Very, very powerful search engines. The source of funds becomes paramount concern. So to be able to document the source of funds is something that we spend a lot of time on at Bridgeford, particularly in the international community. And there's lots of different ways that we go about verifying source of funds, including signed verifications from professionals in the home country to verify that these funds are not drug-related or ill-gotten funds, which is vitally important. And then, the verification of just good character and tax compliance in a home state. South Dakota, and particularly, Bridgeford, is a trust company that asks for proof of tax compliance in the home state. So when we're talking about asking the right questions, just like in everything else, right, Tyler? In order for us to be effective people, in order for us to be effective professionals, in order to protect ourselves, we have to know how to ask the right questions. And these are the right questions. If you're doing KYC correctly, which I believe that we are at Bridgeford, if we're looking at these issues carefully, then we can weed out the nefarious individuals. And I've said all along, not everybody who's coming to the United States is coming for nefarious reasons, just like most of the people that were discovered in the Panama Papers weren't doing anything wrong. The key to finding out who we're working with and avoiding those folks is an effective KYC program. It's imperative to have uniformity of regulations in this regard, and I can tell you why I say that. I worry about top-tier trust jurisdictions that don't have uniformity with respect to how one trust company would do its KYC versus another. If a trust company has a reputation in another state or even within the same state of having requirements that are easier to get through than, say, a Bridgeford, then we have forum shopping or trust company shopping or even state shopping. So I think it's absolutely essential that we're all on the same page here. And I know that the South Dakota Division of Banking is very much aware of this issue and very much in agreement and has really emerged as a leader, not only because of its trust laws, but also because of its compliance and its regulatory environment. South Dakota Division of Banking obviously takes this international influx extraordinarily seriously. And as you see the quote from the banking director appearing in Financial Times, they get it. They own the situation. If there's a problem from a reputational standpoint, South Dakota doesn't benefit from bringing a bad actor in. Certainly the United States doesn't benefit. Bridgeford doesn't benefit. The whole industry doesn't benefit. Nobody wants to end up on the front page of the New York Times. But there's a way to avoid that. And as I said, I think it's in the devil's in the details in the KYC process. South Dakota Division of Banking is working very closely with Bridgeford and other trust companies to develop a uniform set of regulations designed to protect against nefarious actors and really to protect the overall integrity of the trust industry. So we sort of come, as we come to the end of the conversation, I think that the story is this. While we might not like the fact that we're considered a tax haven, and we don't like being called a privacy haven, the reality is that's how the United States is being perceived. People are coming to the United States. We can't be afraid of it, and we need to be prepared for it. We need to be prepared to figure out how to best serve these families because, again, I argue most of them are not bad actors, and we need to make sure we're also protecting the integrity of our banking institution and financial institutions. I believe South Dakota is on the forefront of that in addition to its trust laws. I'm excited to be able to talk about these concepts and to help the South Dakota Division of Banking work towards making sure that they have uniformity in its approach. So from a big picture perspective, why the topic is so important now is we need to be able to address it head on. We can't put our heads in the sand and pretend this isn't happening. We can't be afraid to talk about CRS, and we can't be afraid to understand the nuances of when we need to say no to families coming to the United States.
Great, Dave. I love hearing you talk about this. Obviously, it's something you're extremely passionate about. You bring a lot of energy to the webinar as we talk about CRS, FATCA, all the other different factors that are leading to families coming to the U.S. So thank you for taking the time to present today. We're running right up against the edge of our time limit, so we're going to try and get through some of this stuff really quick. So just a few closing thoughts. We want to thank you all again for joining us for today's webinar, which has been brought to you by Bridgeford Trust Company. For those of you who are attending today's webinar for CPE purposes, you will be receiving one CPE credit for attending today's webinar, and we'll get those sent out within the next 2 weeks. If there's anyone, again, who wants to look at the PowerPoint from today's presentation, it's in the handout section of the webinar software. So if you click in the handout section, you'll be able to download it there and get it there. And also, we'll be posting a recap of today's presentation at Bridgeford's website, which is www.bridgefordtrust.com, and you can look for that post to be up in the next few days. And it looks like it just struck 3 o'clock here on the East Coast, so we want to thank you all for attending. for our attendees in America, for our attendees all around the world. Bridgeford and Dave is really excited to continue to grow and to continue to be a leader in the trust industry space. So, Dave, any final thoughts for our attendees?
Oh, Tyler, thank you very much. Appreciate all the questions. Sorry we couldn't get to all of them. Please feel free to contact me directly or Bridgeford directly. We want to be a resource, and we want to help your clients do this correctly while providing a positive and relevant service to the world community.
Great. Thanks again, Dave, and thank you all for attending. Have a great day.